Good morning and good afternoon to everyone on the line, and welcome to our Navigating the COVID-19 webinar series. First, in those difficult times, I hope that you and your families are all well and safe. Today, we'll be discussing the impact of the current crisis on European M&A. I am Olivier de Villemorin, head of our European M&A practice, and I'm joined by my partners Carsten Berer and Jörg Schnorbers from our Frankfurt office, Richard Pollack, Juan Rodriguez, Ben Perry, and Vanessa Blackmore from our London office, Michael Rodenthal from our Brussels office, and Gauthier Blanc-Luet from our Paris office. Now let's move to our panel discussion. Richard, most of us have been working from home since the beginning of the crisis and have continued managing complex M&A transactions remotely. Can you elaborate on the practical consequences of the crisis on the M&A transactions you are currently working on?
Hey, thanks, Olivier. So I'd say for lawyers, bankers, and deal teams at clients, I think the novelty of working from home has pretty much worn off at this point, and teams are now functioning well and efficiently. Of course, we always still have the occasional cameo appearances by small children running across the screen, but that only provides a little bit of comic relief, so I think we all still have grown to like that. On the regulatory side of things, regulators of all types and in all jurisdictions have slowed down, and we've seen a definite trend in approvals taking longer than usual, and in some cases, a lot longer than usual. And if you're unfortunate enough to have transaction-related litigation, that's also slowed down dramatically with the courts being closed in many jurisdictions. There have also been some tricky issues bankers have been working through on fairness opinions, not the least of which is what to do when their clients have no confidence in the projections, given the extreme disruptions in the world. So from a UK perspective, Ben, what have you seen as the main practical consequences?
Thanks, Richard, and good morning and good afternoon to everyone. As we've closed a number of cross-border deals virtually during the month of April, I agree with you what you just said about deal teams continuing to function well. However, I'd like to pick up on a couple of other points. The first is in relation to financings. Because of the general economic and market conditions, new debt that's specifically for acquisitions, as opposed to for general corporate or liquidity purposes, is becoming significantly more expensive and difficult to secure. And this may continue to be the case for some time. And what this is likely to mean is that going forward, we'll see two things. Firstly, more deals with a share component to the purchase price where that's possible. And secondly, that purchasers who have access to cash will be in a stronger position in a competitive situation. The second point I'd make is in relation to due diligence, where the information that purchasers need to ask for is evolving rapidly to take account of COVID-19. And that really falls into two types of categories. Firstly, there's the enhanced financial diligence focusing in particular on things like liquidity. But on the legal and operational side, it also includes more questions around the potential impact of force majeure on commercial contracts, supply chains, the impact of COVID-19 on the workforce, the operation of IT systems, and the use of terms of any state support. Also, what we've seen in the warranty and indemnity insurance market is that the insurers there are very focused on making sure that they're not insuring any COVID-19 risks. Turning back to how regulators are functioning, I'm now going to ask Jörg to describe his recent experience working with the German financial regulator, the BaFin, on a public takeover.
Thank you, Ben, and good morning, good afternoon, everybody. Our observation here in Germany is that the technical review process is pretty much stable and unaffected during the COVID crisis times. There are basically two main reasons for that. Different to other jurisdictions, such as in the US, the review process is very much predetermined by the law and gives BaFin little or no flexibility to deal with special situations once the process has been initiated. After the formal publication announcement of the intention of a bidder to do a transaction, it has to file the offer document within 4 weeks with BaFin. Upon filing, the BaFin has just 10 business days, which includes Saturdays, to review and approve the offer document. Only under special circumstances, in particular if the disclosure in the offer document is not in compliance with the law, BaFin may extend the review period by further 5 business days. Reasons relating usually to the COVID-19 crisis do not justify the extension of the review period. If the BaFin does not within the limit time frame approve or forbid the offer document is deemed to be approved by law, and the bidder must commence the offer immediately. Therefore, neither the bidder nor the authority is in a position to stop or postpone a public takeover offer once a decision to launch one has been formally announced. The second reason for this observation is that the regulator, the BaFin, is doing an incredibly good job. As always, they are handling the process very professionally. In Corona times, as we have seen this in investment banks and other institutions, they divided the staff into teams. In the A team or in the Q team, as you like, are working remotely from home, and the other team, the B team or the blue team, are covering in the office. The review process is now in those times pretty informal. You have calls, people from the BaFin call in from home. You get even comments by short emails. So at the end, the only document you have printed in your hands is then the approval of the offer document. And clearly that's the best document you can have in your hand. Olivier, I understand that in France, your experience with the AMF is similar to what we see here in Germany.
Yeah, thank you, Jörg. Yes, exactly. I think that the process, it's been clear over the last few weeks that the process with the French regulator is pretty much unaffected like in Germany. We have several transactions that are currently being reviewed by the AMF, and they're working remotely, and they're complying with very short deadlines, and they are as professional as usual, and provide and understanding the situation and understanding the very tight timelines that we have. So I think that generally European regulators are very cautious to allow the market to continue working. Karsten, we know that the lifting of the lockdown does not necessarily mean the end of the crisis, and the M&A activity is being significantly impacted by this crisis. Do you think that there will be a quick rebound of the M&A activity before the summer, or do you think that issuers and corporates will wait and see whether there will be a new pandemic, and if the volatility is less important towards the end of the year?
Hello, Olivier. This is very difficult to say. It would be great if I knew the answer to the question, but the timing will generally, of course, depend on when businesses can be reopened and when our economies in the different countries get back to at least what will probably be a new normal. Stating the obvious, the longer the shutdown will take, the more difficult it will be to see a quick rebound also in M&A activity. But let me add a few further, more specific thoughts on your question. First, some rescued distressed M&A activity may be visible quickly. That is something that we already see now. Secondly, my assumption is that the strategic reassessment of other corporates, which may lead to divestitures or acquisitions, may take a little longer. We see a lot of discussions at the moment here. So corporates are not only discussing the defense case, how to best manage the crisis, but also the future case, including strategic reassessments and potential acquisitions. However, it may take longer. Thirdly, and again, not surprisingly, PE may be back quickly as soon as financing is available to make use of opportunities, including P2P. the fundamental situation that PE is sitting on a lot of money to invest has not changed. Finally, and that is inherently uncertain and hopefully not true, acquisitions by US companies into Europe may perhaps be more selective, both because of other opportunities within the US and a temporary refocus on national markets. But this may, of course, vary from industry to industry. And if they see opportunities in Europe, I'm hopeful that also US companies will make use of these opportunities. Gauthier, what are your thoughts on this topic?
Well, thank you, Carsten. Now, it's quite clear that this crisis is going to have a lasting impact on the economy. And the problem is that, as you just said, it's quite difficult to figure out what's going to happen and when. Nobody really knows how and when the economy is going to recover. And this is going to affect the M&A activity for quite a while. Now, this being said, it seems to me that the interesting question is more whether this unstable environment is going to have a negative or positive impact on the M&A activity. May well be that businesses affected by the crisis will focus on their recovery plan rather than looking around for potential targets, or they will just become risk adverse as long as the future remains uncertain. But others will, of course, want, as you said, to seize opportunities, in particular with respect to business which could have a strong recovery potential. And more importantly, and as it has always been the case, M&A is going to play an important role in the reshaping of the economy. So what I think is that as long as liquidity remains available, as long as the equity market remain open, M&A should still, be a big driver for growth, in particular in a low growth environment like now.
And to jump on that, thank you, Gauthier. The question will be, which players will be best positioned to take advantage of this crisis, and which ones will be able to be acquisitive versus those who will be viewed as targets. Jörg, I know that there have been a lot of discussions in this respect in Germany, but do you expect more private transactions or strategic combinations, or are you seeing more types or minority stake transactions, currently?
Yeah, at least thank you, Olivier, at least from our discussions with investment banks and private equity players, we believe that pipe transactions will play a significant role in the upcoming months. What are the reasons for that? And an issuer, if it wants to do a small capital raising comprising 10 or 20% of the share capital of the company, it will do this usually by an accelerated book build offering. Accelerated book build offerings have largely been executed in industries, however, that are stable, unaffected by the crisis, or even the winner of the crisis. For capital raisings in more difficult industries, the risk premium and therefore the discounts to share prices for institutional investors would request are still discouraging issuers from going out into the market, if at all possible. We see this in particular in the media market. However, some investors, such as strategic buyers, family offices, or private equity funds, may have a special insight into certain industries and may so be willing to move forward at acceptable prices. Further, companies may be concerned about their low share prices and seek protection against unsolicited takeover bids by issuing equity through a pipe transaction to investors that they consider as stable, long-term oriented, and somewhat immune against short-term takeover offers. And finally, we have already seen some investors opportunistically increasing their already existing stake in listed companies.
Yeah. And thank you very much, Jörg. That's key. And on the private equity side, private equity buyers are really viewed as potentially the big winners of this crisis because of their dry powder and all the funds that they have raised. And they've already announced that for some of them that they want to focus on distressed assets or companies which have significantly suffered as a result of the crisis. Richard, how do you view things in this respect?
So I would say, Olivier, it's something of a mixed bag. I think it is true that, as you and Karsten and Jörg were all saying, there is a ton of dry powder out there. And we have seen a number of firms actively looking at opportunities that have suddenly become better priced. But we've also seen firms that aren't traditional players in the distress space begin to invest heavily in getting up to speed on how to get involved in distress situations, which is, has some unique technologies and unique issues. And they're spending time with our distressed folks, for example, trying to learn the ropes of those types of deals. But at the other end of the spectrum, there are many PE shops who have severe issues at their existing portfolio companies. And in some cases, those firms have stopped looking at new opportunities because working out the issues in the current portfolio is soaking up all of their bandwidth. So I don't think you can say it's across the board all positive or the PE is going to be the saviors of all these distressed industries. Gauthier, how about you on the corporate side? What have you been seeing?
Yeah, as you said, Richard, unlike in the aftermath of the financial crisis, there is indeed a lot of liquidity in the system, but not only in the PE sector. Certain corporates have quite a lot of dry powder too, in particular among those who won't pay dividends this year. Not all of them are going to suffer from the crisis. And indeed, we are starting to see players in the industry looking around for growth opportunities. That's something that Karsten touched upon before, and I think we see this also in other countries like France. So once the rescue plans will come to an end, and when all this cash coming from the governments is going to dry up, probably certain businesses which have been more affected than others will turn to industry consolidators to finance their recovery plan. So probably we're going to see strategic actors focused on undervalued or even distressed companies with a sort of strong future. Or even startups, former unicorns, in particular those who could be thinly capitalized and who cannot access to the equity capital markets.
Yeah, thank you, Gauthier. I think you're right on the corporate side. It's likely that the groups which have been the least affected by the crisis will also use that once everything stabilizes as an opportunity to make the acquisitions which were maybe too expensive before the crisis. Or maybe that when were to be paid in cash, and now maybe they could, shares could be accepted, or a combination of shares and cash. So it's also going to be an opportunity for large corporates to look at external growth at multiples which are maybe more reasonable than those that applied immediately before the crisis. Talking about multiples that are reasonable and the fact that the market currently is extremely affected, the European Commission has called the European countries for more protectionism with respect to their strategic assets. Spain and Italy have lowered their review thresholds for non-EU buyers to 10%. Germany is considering also lowering its standard of review, and it's before the parliament in Germany, if I understand correctly. Karsten, do you think this protectionism is justified? Don't you think it's going to have an impact on the ability of the group to recover their pre-crisis valuation in the coming months?
That is a very good question, Olivier. If you ask me personally, protectionism is an obstacle to increase economic wealth and prosperity, but I know this is a political statement as well. So from my perspective, by definition, protectionism does not help M&A activity. both in terms of valuation, and that was part of your question, and in terms also of transaction certainty. But open markets for M&A require reciprocity, and China and now also other countries seem unwilling to provide a level playing field. This initiated the therefore partially legitimate reaction from certain European countries that you mentioned. In addition, we have to acknowledge that we live in times where almost all European governments politically support the protectionist approach to avoid the loss of know-how and to protect employees, which means that they are not sufficiently considering the economic rationale included in your question. Rather, the other way around, further industries have been identified during the crisis to be of systemic importance and will now be included in the list of industries and sectors to be protected. So we have to live with this for the time being, I think.
Yeah, no, I agree. And interestingly, while France has always been at the forefront of the technology in terms of foreign investment regulation, in fact, the current regime is less protective than the one that applies in Italy and Spain, which is considered as temporary just for everybody, because it's supposed to apply on a temporary basis. In Italy, I think it's until December 31st. And while in those countries 10% is the review threshold, in France it's still 25%. And even if the new regime entered into effect only on April 1, in fact, it had been modified back last year before the crisis. So there is a real question mark as to whether the French government will want to further modify a regime which has been modified a few months ago, or whether they will just stay with the current situation, which does not provide the necessary protection for minority investment, opportunistic minority investment, because this is what we're trying to deal with. By lowering the threshold to 10%, it's not the acquisition of control, but it's more an opportunistic minority investment of 10, 15% in a company which has a pretty broad shareholder base. So there's a real question mark as to whether the French regime will be modified. And I agree with you. I think this may have an impact on the valuation. It will have an impact on the overall liquidity of the market. And also it raises numerous issues, which are, how do you, when you have such low threshold, how do you deal with passive crossing threshold? Do you take into account concert action? Would asset managers need to be excluded? All those aspects, which do not necessarily have to be dealt with when the threshold is much higher, become an issue when you're around 10%. But, it's interesting to see that you don't necessarily need to have a very strict regime to be protective. And the UK, which does not have a specific foreign investment regime, does provide for certain protection. Vanessa, do you want to speak a bit further about this?
Yes, thanks very much, Olivier and Carsten. I think generally over the last few years we've seen a trend towards more interventionist approaches in various countries. The UK is different from France and Germany and many of the other European countries, because in the UK we don't have a specific regime that requires pre-closing notifications and clearance of foreign investment. In the UK, the government's powers to intervene on public interest grounds actually derive from our UK merger control regime. And the only grounds under the merger control regime for intervening are national security, media plurality, and prudential supervision of the financial system. In the UK, the general merger control thresholds were actually broadened back in 2018. And that was to lower the threshold for potential intervention for dual use items. And by that we mean items that have a military and civilian use, for multi-purpose computing hardware, and also for quantum-based technology. And at the time, the government also consulted on introducing a specific national security type of regime, but so far those initial consultations haven't really gone any further. And I think if we look back over 2019, going back to sort of the comment about seeing a more interventionist approach, 2019 was actually notable for a number of interventions. Most notably, there were two private equity take-private transactions for Inmarsat and for Cobham that the Secretary of State sort of intervened and looked at it. They both got passed, but that they were both listed companies in the defence sector. And in addition, again, continuing on this theme of intervention, as Juan will talk about later, the UK's Competition and Markets Authority has begun to intervene in a number of transactions, but this trend sort of predates the COVID-19 crisis. And I think it's also worth just touching on another situation that's been in the news lately, which is outside of the M&A context, and that relates to a company called Imagination Technologies. It's a UK chip maker that was taken private in 2017. And in that situation, based on the press reports, there's been a dispute about an attempt to make changes to the board and the level of control by a Chinese government sponsored fund. And the UK government called a meeting with the company, and those plans are now no longer going ahead. And in fact, the company has just recently announced that it's committed to continuing to invest in the UK. So I think that's sort of a sort of interesting overview of, I think, the direction of travel in terms of where intervention it has been seen and where it might be going.
Yeah, thank you very much, Vanessa. I think it really means that you don't necessarily need a very detailed, specific regime for the UK government to be able to intervene. I think that we are in an environment of depressed market valuation, and we've seen a significant increase in the US of rights plans adopted by companies since the beginning of the crisis. Even, in fact, proxy advisors such as ISS have communicated that they could approve those plans if they met certain criteria. Ben, have you seen the same movement in Europe? And other than through foreign investment regulation, what can European groups do to protect themselves against hostile takeovers or just opportunistic acquisitions?
Thanks, Olivier. I'll answer as far as the UK is concerned. And what we have always seen here is that there's a combination of two factors. Firstly, the constraints of UK corporate law, and second, the prohibition in the UK Takeover Code on companies taking frustrating action. And what those have meant is that you haven't seen US-style takeover defense tactics coming into the UK, and that's very unlikely to change, really. However, it's worth stepping back a bit and mentioning that there's a number of aspects of the UK Takeover Code, which was substantially rewritten just under 10 years ago after the Kraft-Cadbury transaction, and that the collective effect of those provisions is to make the takeover landscape in the UK quite a bit more geared generally towards protecting target companies. And the two features worth mentioning are firstly in the put up or shut up regime, under which a potential bidder can be put under a regulatory deadline to either make a firm offer or to walk away. And secondly, there's a general prohibition on target companies entering into most kinds of deal protection arrangements. So that's really the story as far as the UK is concerned. What about France?
Yeah, thank you. And just on the put up or shut up, other European countries copied the put up or shut up regime with their own features, such as France. But I know that there are other European countries that do have the same regime since it was adopted in the UK. In France, there has been a recent new debate about poison pills. The regime was adopted back in 2006, which allowed the French issuers to issue the equivalent of rights plans in the US and warrants that would dilute massively the acquirer in the context of a hostile tender offer. So those warrants are issued to the existing shareholders, and if the tender offer is not recommended by the board, the company can dilute the acquirer and issue those warrants to the benefit of the existing shareholders. That works only in the context of a tender offer. It doesn't work in the context of an activism campaign, and there may be further thoughts of expanding it, but at least right now the regime is just for a tender offer. And at that time, many companies adopted the plan because it was new and they thought it was a good idea. And since it has to be renewed every year, progressively, most companies, in particular in the CAC 40, abandoned the difficulty of convincing the shareholders every year to approve that warrant plan. Only a handful of companies today do have that plan, such as Bouygues, Accor, and certain others. But in light of the current context, there have been discussion, and this is pretty recent, as to whether issuers should not be reconsidering adopting that plan, in particular since a lot of shareholders' meetings have been postponed to June 30, so they would have time to modify their resolutions and include in those resolutions those warrant plan poison pill regime. However, the issuers are still very reluctant because they consider that it can be viewed as pretty defensive. Also, they're worried about the impact on their share price. They also worry that they won't be able to convince the shareholders to adopt such plans. And also, they haven't thought enough about the conditions which would apply in order for those plans to be adopted. So it's really a recent debate. It's difficult to know today whether there would be not a wave, but at least an increase in the number of plans adopted before this summer. But at least we know that many issuers are thinking of that, and that certain issuers association are promoting the idea that they should adopt such plans. What do you see, Jörg, in Germany?
Thanks, Olivier. Yeah, it's interesting to see that the situation in Germany is somewhat different to the UK and France. We don't have, and we always get questions from clients in that regard. We don't have the put up, shut up regime. We don't have poison plans. I would say Germany is a very pretty liberal country in terms of taking over companies. We definitely have regulatory issues you have to take into account, including our CFIUS regime, including German antitrust and European antitrust limitations. But other than that, if you have the financial means and the shareholder cooperate, then a bidder is in the position to do a takeover offer. Yeah? Historically, Germany, we have seen very few unsolicited, even unfriendly takeover offers. There was the Vodafone Mannesmann transaction in 2000. People who are my age might remember it. But except of that, I think we have started seeing in the last 10 years more hostile transactions where we worked on the bidder side or on the target side. And we have seen more aggressive tactics coming over from the United States, including the Christie Berhag letter and approaching a target company with a fully prepared set of offer documents and asking the target management on a Friday evening, are you willing to accept our business combination agreement and negotiate with us over the weekend? Otherwise, we will file with the BaFin the offer document on Monday, whatever you do or not. So today, in particular in crisis times, transaction preparations seriously take into account the option of an unsolicited approach as an alternative route. And besides a more generic defense manual, every target company should have in place, target companies of all sizes tend to consider the option of an unsolicited approach as a realistic issue.
Thank you, York. Yes, linked to homicide takeover, everybody, of course, we think of activism. That's the other possibility. We know that Europe has been subject to an increasing number of activism campaigns before the crisis, and this had been going on for several years now. And taking into account, of course, again, the stock market valuations and the dry powder that some activism funds may have, Carsten, what do you anticipate? Do you anticipate a significant increase in activism campaigns in the coming months, or do you think that it should more or less remain as it was before?
Olivier, I think we should anticipate a significant increase here. As you say, this increase of activism campaigns has been a clear trend pre-crisis already. And I personally think that the crisis will be a catalyst for a significant further increase. Of course, stating the obvious and given the circumstances, the activists may now come with different topics than they had on their agenda before. So what I mean is perhaps less with the request for share repurchases or other distributions of liquidity, but rather corporate measures such as divestitures, spin-offs, and other strategic transactions. So even though the topics may change, we clearly advise our clients that the old golden rule still applies, that the companies should be well prepared and try to anticipate these campaigns by proactively addressing the potential topics in their investor communication. That's definitely the key first step to be successful in order to address activism campaigns and to go through this campaign successfully in the end.
Yeah, no, I agree with you. I think there's going to be an increase, and I think the only thing is going to be difficult to make a difference between an activism campaign and an opportunistic investment because of the current prices, and a lot of investors are going to be viewed as activists. As you say, Carsten, groups will be very focused on corporate measures to get their share price back to a pre-crisis level. And for those who have a strong business model, but for which it will take a little bit more time to get back to that level, they are the ones at risk. For example, the sound business models that were a little bit over leveraged before the crisis, and which face liquidity issues, and which are viewed as too leveraged by the market, even without any liquidity issues, have seen their stock price decrease significantly. And although the model and their activity may get back to where it was before, the stock price will take longer to recover. So those ones should be particularly cautious. Interestingly, in France, we have had two activism campaigns, one on the M&A side, which was the Altran Elliott campaign. Elliott was complaining about the price paid by Capgemini for the acquisition of Altran. And just after the beginning of the crisis, while it had announced that it would not tender its shares, it realized that it may be safer to do so. So I think that on those type of activism campaign may not be as common as they were before. On the other hand, we have corporate governance, as you mentioned, Carsten, and we have one that is ongoing between Amber Capital and Lagardère. And this is clearly a corporate governance because it's based on the structure of the company itself. And interestingly, the battle will be during a behind closed door shareholders meeting at the beginning of May. So we have the first shareholder activism campaign, which is a virtual one, basically. Vanessa, in terms of activism, what do you see in the UK?
Thanks, Carsten and Olivier. I think, picking up on what Carsten said, if you look back to 2018, 2019, there is a clear trend pre-crisis of increasingly activist shareholder activity. In terms of the here and now, at this point in the UK, we haven't really seen any new activist campaigns where activist shareholders have been challenging a board's strategy for responding to the COVID COVID-19 crisis. And actually what we have been seeing is that activists have been temporarily suspending their campaigns. An example of this is Shareholder in relation to Barclays. And I guess this is unsurprising in terms of the immediate crisis, given the market volatility and the potential reputational risks of pursuing a campaign in the context of a global health crisis and what is becoming an economic crisis. But I agree that sort of looking forward, I agree with what you've both said. As a practical matter, in the UK, a majority of the annual general meetings of the FTSE 100 companies in the current season are actually due to take place behind closed doors, and they will be held by 2 board directors usually, and so that's going to preclude shareholder participation and the opportunity to ask questions. I think again, more broadly, one possible area of conflict that we may see emerging is between boards and shareholders is around companies' decisions to cancel their dividends and share repurchase programs as they attempt to bolster their balance sheets. And I guess we'll have to wait and see how that all plays out.
Yeah, I agree with you. Gauthier, you often deal with board of directors, and in light of the current market volatility and uncertainty as to the impact of the COVID crisis on businesses, what steps should board take in order to make themselves comfortable in assessing an M&A proposal, both when they are on the acquirer side and target side?
Thank you, Olivier. Well, board are going to be faced with many more challenges than in normal circumstances. First of all, they, as usual, they would need to make sure that the price and all the other financial terms of the transaction are fair for the company and its shareholders. It could be a challenge to reach that conclusion in the current environment. It's clearly much more difficult now than ever to get comfortable with projections in future performance. Recent transactions in the sector may not provide benchmarks anymore. Multiples, discount rates are going to be deeply impacted by the crisis, depending on the sector. So overall, a much more difficult exercise to go through. And on top of that, one other challenge may come from transactions involving targets with significant tax losses, which is a situation we'll probably come across quite often in the near future. So as always, sellers will try to monetize these losses by increasing the price, and buyers will try to discount their ability to benefit from these losses because of future uncertainty on the profitability of the business, for example. So this discussion, which is usually difficult, is going to be even more tough in the current situation. I'm not sure that all boards will have all the cards in their hands to make an informed assessment on this delicate issue, because the truth is that the valuation of tax losses is always a very difficult exercise because value depends on the effectiveness of the losses, which is always a challenge to measure and to audit. And value also depends on the availability of those losses to the buyer, which is always subject to some uncertainty. And maybe one other thing to mention, boards will also need to take a much closer look at a series of execution risks, like the financing risks and regulatory issues. For example, deals requiring financing are going to be put at a disadvantage in a period where financing is less available. for those deals which will require extensive regulatory review, which we're going to talk about in a minute, those deals might be more difficult to get done. And once all those risks are identified, then the next question is, what is the appropriate allocation of the risks between the parties? All questions boards will have to answer again. On that last bit regarding the allocation of risk, Richard, would you like to tell us a bit more about that?
Yeah, thanks, Gauthier. And I agree with everything you just said, actually. I'd add that in many ways, the issues remain the same as always, but with a heightened awareness of the importance of how the risk allocations work in situations where, for example, we could have a recurrence of the pandemic, or governments order further shutdowns, or the oil markets stop functioning again, or the buyer's financing falls through. All of those things are risks that were allocated, sometimes more or less clearly in M&A agreements already, but people on both sides of deals will now have an acute awareness of how things can play out. And you should expect that all of those points are going to be negotiated much more intensely than previously. Related to that, in some of the fights that are going on now, in many situations where buyers are trying to find ways out of transactions, you can see in the court papers that have been filed that the buyers are searching for alternative ways to look for outs under the agreement if there's either no MAC clause in the agreement or if they're in a jurisdiction that's not sympathetic to MACs. So people are looking closely at breaches of interim operating covenants, even things like access covenants, like, can I get access to the properties I'm buying during a government shutdown, and other things like that to seek an exit from agreements. So for new deals that are being negotiated now, you can expect much tougher negotiations on each of those types of provisions as well.
Yes, and Richard, you mentioned that some buyers may try to use MAC provisions to get out of the deal. Can you elaborate a bit more on how that would work and what they could do?
Oh, yes, Olivier, MACs are tricky, right? At some level, you look at this crisis and you think, if this isn't a material adverse change, then what could possibly be? But you have to go through a number of questions, and each of them is likely to be litigated, and it won't be surprising if you get different answers in different courts. So first is, how is a MAC defined in your agreement? In many European agreements done over the last few years, pandemics are actually expressly carved out from the definition of a MAC. So then you get to the question of whether what you're dealing with now is just a pandemic, or whether things like the government's ordering closures around the world are a separate event that may serve as the basis for saying there's been a MAC. Next, courts in some jurisdictions have focused on questions like whether the event is temporary, maybe only lasting 1 or 2 quarters, or whether instead it's expected to have a long-term impact on the business. And I suspect that parties are going to have to litigate that exact question for the current crisis as well. And the answer may come out being different for different industries and maybe even different companies within various industries. And the other issue is MACs often have a concept of disproportionate impact on a company versus the other players in its industry. And I think that's also going to be, that's also a very fact-specific question, whether that's happened here, given that every industry is impacted by this crisis. But of course, that doesn't mean that every company is impacted to the same degree. And I think all of those are issues that are going to end up having to be litigated in the end.
Yeah, thank you very much. And you're right, it's really a case-by-case situation. And although one may think that this is a MAC, it does not necessarily give an out. The current situation does not necessarily give an out. If we move to our antitrust team and to the antitrust aspects of the transaction, Juan and Michael, on the antitrust review process for ongoing transaction, have you seen, Juan, significant delay? And how are the competition authorities dealing with the current situation?
Thank you, Olivier. I may be tempting fate here, but actually, surprisingly, so far, we've not seen significant delays. It's very clear that the European Commission is going to great effort to provide normal service in merger cases, maybe not in other types of business, but merger and state aid cases are really where all the resources are going, even though the Commission is working entirely remotely at the moment. The greatest challenge for the Commission, which really can affect timing of ongoing cases, is whether they can obtain input from the key third-party stakeholders, like emerging parties, customers, and competitors, because that input really is key evidence in their investigations. And if they can't get it because the parties concerned are just not at work or not contactable, then the investigation clearly hits a roadblock. In that sense, the pandemic has really put the timing of merger review in the hands of those third parties to a greater extent than would normally occur. That said, the Commission appears to be clearing simple cases, pure financial investments, where there's no competitive overlap of any magnitude, much quicker, because those cases don't need third-party input. To give just one example, one of our pretty straightforward private equity deals, an acquisition of joint control of a target where there's not much overlap, was cleared by the Commission last week only 2 days after the legal minimum waiting period, so on day 17 after filing. Strangely, I think that's quicker than would be the norm, where at the very least you'd expect the clearance not to come until about day 20. In another case that we have right now, a more complex matter that's in pre-notification and has been for several weeks, there's been a minor delay, really a matter of a few days, and nothing that jeopardizes the overall timetable. Probably the greatest risk of delay will arise in complex matters that are at an early stage of pre-notification with the Commission or have yet to start pre-notification. Of course, to speed up closing, there may be a chance to seek a derogation from the waiting period under the EU merger rules. Now that procedure has always been there. It's not used very often. The Commission hasn't changed the rules and doesn't plan to change the rules or the procedures because of the pandemic. Emerging parties will still have to show that the deal raises no significant competition, anti-competitive effects, and very importantly, that they or third parties will suffer serious damage from any delay to closing. In fact, the most frequent use of this derogation procedure historically has been when the target is in imminent danger of insolvency. So insolvency caused by COVID or accelerated by it could certainly be a potential ground for a derogation application. Looking at the UK, so for the CMA, it seems to be business as usual as well on the merger side. They're making no changes to their deadlines or their processes, although they are saying, like the Commission, that there could be delay if third-party stakeholders don't provide their input on time. I think more importantly, COVID-19 aside, to pick up on the point that Vanessa alluded to, the CMA really has in the last year to 18 months carved out a bit of a niche as being one of the most interventionist and aggressive authorities in merger control. You've only got to look at recent cases like Sabre and Fairlogics and Roche and Spark to detect a new, much more interventionist attitude from the CMA, particularly in sectors that it regards as highly sensitive, for example, health and technology.
Thank you, Warren. Michael, do you expect the European Commission to be more flexible to allow the creation of a European champion, or will they continue to be as strict as they were before the crisis?
Thank you, Olivier. Let me first start by saying that I agree with everything Juan has said. Here on the ground in Brussels, I can confirm that the Commission's merger shop is open for business. There are no material delays, in particular as far as relatively straightforward cases are concerned. If you need to discuss derogation matters with them, they're quickly on the phone with you, and they're overall very business-minded. So somewhat contrary to an unfortunate statement they issued at the beginning of the lockdown here in Belgium when they suggested that filings would better be delayed. So that's not true. That's not true. That's not in sync with reality. Coming back to your question on European champions, that's an old debate, of course, and unfortunately, I don't think that the current crisis will have much of an impact here. It will require a reform of the EU merger regulation to introduce industrial policy considerations into the European merger regulation substantive test. Same for introducing a political veto right. Even that's not currently in the cards, not even after the French-German manifesto, which was issued following the Siemens Alstom prohibition decision. Instead, in the absence of a reform, it will be business as usual, with the Commission using and enjoying its old, fine-tuned tools, such as for market definition when it comes to European mergers, or the assessment of potential competition from outside the EU. And all of this based on the merger regulations bedrock principle of impartiality.
But at least, to give us good news, at least they will be more flexible on the acquisition of distressed assets.
Would love to share some good news with you, Olivier. Unfortunately, also on that front, I don't know whether you guys have seen the CMA, the UK Competition Authority, just cleared Amazon's acquisition of a minority interest in Deliveroo, and in this context made clear that everyone understands that while this acquisition was cleared under the failing firm defense, its approach hadn't been changed, was as strict as always. And I would expect the EC to act along the same lines. They're also unlikely to relax the rather tough standard for dealing with the so-called failing firm defense. And the term defense already shows you what you're up against. Under the EU's test, parties need to show three things. First of all, in the absence of the rescue merger, the failing firm would in the near future be forced out of the markets. Second, there's no better buyer from a competition perspective, so no buyer that creates fewer competition concerns than the proposed buyer. And third, in the absence of the merger, the assets of the failing firm would inevitably exit the market. That's a tall order, and also a very time-consuming strategy, with the parties bearing the burden of proof and needing to having to show the evidence for the Commission to show that this is actually likely to happen, not just mere speculation. But certainly no mission impossible. There are a few precedents out there in the past, so maybe I end the answer to your question on a positive note. So there are precedents that show it can be done.
And Juan, one last quick question before we end this session. In light of the time period now to close deals, do you think on the interim operating covenants it will be easier to have more flexibility from the Commission?
Well, I wouldn't assume that the Commission will be an easy nut to crack in this regard, but it's certainly not impossible. The Commission may, in specific circumstances, accept unusually broad or invasive interim covenants if they can be justified in those circumstances as being necessary and crucially proportionate. So not going beyond what's really necessary to protect the acquirer from the loss of value that the covenant is intended to prevent. And clearly, if there's any doubt about whether a covenant is so far off the standard to be problematic, one can always consult with the Commission, and they encourage that. They have an open door policy. Even when their doors are physically locked, as they are right now. But certainly they are capable of being consulted, remotely. If the Commission concludes that the covenant itself, or even all of the covenants taken together, would amount to an acquisition of control, then of course you need to go and apply for a derogation using the time-honored process to allow the Commission to really do a balancing test between the likely effects on competition of the deal and the need for it to be closed quickly to prevent irreparable harm.
Thank you, Ron. Thank you, everybody. That brings us to the conclusion of today's European M&A webinar. On behalf of the panel, we'd like to thank you for joining us today. If you have any question regarding any of those topics, please do not hesitate to reach out to any of us or to your usual SNC contacts. Also, please join us on the upcoming other European webinar on European capital markets, which will take place on this coming Thursday, April the 30th. And you can visit also our website for any COVID-19 or related aspects. Stay safe and well, and thank you.